Welcome to the ASEAN Intellectual Property Rights film. This video has been produced as a general guide to intellectual property protection in ASEAN countries and informs you about the benefits deriving from such protection, especially from the development of indigenous technologies and the transfer of know-how. The rights explained here are patents for inventions, plant varieties, industrial designs, trademarks, geographical indications, and copyrights. Owing to the competitive nature of business, intellectual property rights protection is one of the key means of enhancing your competitiveness. Ignore intellectual property rights at your peril. Your business may suffer. Judicious use and protection of intellectual property rights can ensure that your business really prospers. It pays to heed intellectual property rights, so stay with us as we take you through this film. Some people think patents are all about eccentric inventors with bizarre and impractical notions that have no place in everyday life. But in the world at large, things such as the ring pull used on Coca-Cola cans have enjoyed patent protection. You can also obtain a patent for improving an existing idea, such as adding a Velcro to sports shoes to replace shoelaces. The fact is, the patent system is of value for worthwhile inventions, and it increases the prospects of an economic return. After all, patents are about money, and most people take that seriously. A patent can be described as a legal bargain between the state and the patent proprietor. In exchange for a full technical disclosure of the invention and the payment of certain fees, the holder of a patent is entitled, for a limited period, to an exclusive right in his invention. This is the right to prevent others from manufacturing, selling, imparting, or using the proprietor's patent invention without his authorization in a specific territory or a group of territories. Many inventions are concerned with, for example, engineering, chemistry, computers, and medicine. And many patents are granted for incremental inventions, which consist of small but important improvements to existing products and processes. So it's not necessary to invent something as remarkable as mobile phone technology in order to obtain patent protection. Just about anything can be patented, from a hinge to a satellite dish. But before a patent can be granted, there are certain main requirements which have to be met. Generally, the key requirements for an alleged invention to be patent are that it must be new, involve an inventive step, be capable of industrial application, and not be excluded from protection. These key patentability requirements are acknowledged worldwide as the criteria for patent protection. Be careful. The early disclosure of your invention in written form, such as a published patent specification, a book, a magazine, a report, or an article, prior to the filing of a patent application, will destroy novelty. Disclosures can also be in spoken form, such as the detailed description of the invention on radio or television or in academic papers disclosed at conferences. The invention or any information can become publicly available simply by use, for instance, by manufacturing and then selling the invention, or it could be tested in public. Examples of the fields which are usually either excluded from patent protection or are not regarded as inventions are a discovery, scientific theory, or mathematical method, a literary, dramatic, musical, or artistic work, or any other aesthetic creation whatsoever covered by copyright. A scheme, rule, or method for performing a mental act, playing a game, or doing business. The presentation of information. To find out the specific requirements that must be met to protect your invention, contact your National Intellectual Property Office or a patent attorney or other professional advisors. In general, the best advice is to keep your invention secret and don't tell anybody about it until you have filed your patent application. Usually 18 months after the filing of a patent application, it is published, and the public is made aware of the technical information contained in the invention. There is no need to go to extreme lengths to obtain such technical information, especially when it could all be quite unnecessary. In fact, patents provide the world's largest single source of technical information. There are over 55 million patent documents, a collection increasing at a rate of about 1 per minute of every day of every year, and patents are normally the first disclosure of technical information. In addition, this vast storehouse of information is available to the general public and can be used by you, regardless of whether you ever file a patent application yourself. The information can be used either to invent and improve technology or to solve technical problems without prejudicing the original inventor's patent rights. It's not commonly known that most patent information cannot be found elsewhere. In fact, over 80% of patent information is unique to the patents themselves and exists in no other forms. A vast amount of information is readily available in the world today. There are also ASEAN optical discs containing patent publications of the ASEAN countries, which are also available from the National Intellectual Property Offices. So, if you don't look at existing patents, you are cutting yourself off from at least 80% of the available information. This is information that could also be used to work out the possible future activities of known competitors and, more importantly, potential future competitors. A patent eventually expires after a set number of years. According to the international practice, a patent expires 20 years after the filing date. More commonly, however, the patent is not kept in force for the maximum term. This means that most of the 55 million patent documents worldwide represent free technology which you can use. But make sure that by using such technology, you do not infringe previous patents which may still be in force. Using patents as a source of information can help you avoid duplicated research and development. Furthermore, you might find that looking at patents can solve a difficult technical problem, or give you inspiration for an entirely new approach. At the least, a search may ensure you do not infringe on other people's patents. For a long period of time, people across the world were able to improve and create new plants, but they had no means of protecting their works. If such hard work could be easily stolen, how could people be encouraged to create more varieties and thereby more food and of a higher quality? To solve these problems, a new intellectual property right was created in the 60s. Plant variety protection, or breeder's rights, which gives the invented breeder an exclusive right to produce and sell seeds of the variety protected for a period of 25 or 30 years, depending on the species. How does this new system work? First, As for a patent, the plant variety to be protected must be new. For plant varieties, this means that it must be distinct from all known varieties. Furthermore, the plant variety needs to be homogeneous, which means that all the plants of the same variety have to be similar. Finally, the plant variety needs to be stable, which means that all the plants of the same variety have to be similar every year. These requirements are verified by experimentation in the fields. To develop new plant varieties, breeders need access to existing varieties and their genetic materials. This access does not require the authorization of the plant variety owner. Plant variety protection allows a country's farmers to use a plant variety to produce their own seeds if they pay an appropriate fee to the plant variety owner. Finally, plant variety protection boosts the creation of improved varieties and enables progress in agriculture and food. Today, the International Union for the Protection of New Variety of Plants, or UPOV, administers the worldwide protection of new varieties. For more information on your national system regarding plant variety protection, you may contact the National Intellectual Property Office or competent department of the Ministry of Agriculture. You may not realize it, but the shape of these speakers may be protected under design registration. Like the shape of this car, for example. These days, the selling of new products relies very much on their appearance and how that appearance appeals to the potential purchaser. People are now more aware of design and will seek out a product that in many cases only really differs from a competitive product in the way it looks. So if you believe that the appearance of your product is important, you need to think very seriously about registering it. If available, registration will give you an exclusive right to the design and protect it from being copied by your competitors. But just what is considered a design? What articles can be registered, and how do you go about it? Generally speaking, an industrial design is the ornamental or aesthetic aspect of an article, which may consist of the shape, pattern, or color of the article and must appeal to the sense of sight. There are, however, some exclusions. What cannot be registered normally are purely functional designs where aesthetic appeal is not normally taken into account. There are other specific exclusions, and you should note that the registration of a design does not include the materials from which a product is made, or its purpose. Assuming that your design is eligible for registration and a national registration system is available, you generally first apply through your national IP office and provide representations of the design. There must be no doubt about what you wish to protect. Registration is for a specified article or articles. A soap in the shape of a car would not infringe a registration for an identical design for a car. So, you must specify precisely the type of article to which the design applies. For example, a tennis racket or a perfume bottle. If and when all requirements are met, a certificate of registration will be issued, giving you protection for a number of years. Design registration and terms may vary between countries, so consult your national IP office or a patent attorney for precise details. To a customer, The Three Stripes trademark stands for the world-class quality sport wear of Adidas. And the Tiger trademark makes this well-known balm easy to recognize. Trademarks help us to identify different products and services and to tell them apart. But what is a trademark? It is any sign which can be represented graphically and is capable of distinguishing one company's goods or services from those of another company. Such signs can usually include words, letters, logo, and the shape of goods or their packaging. A trademark could very well be the most valuable marketing tool a company possesses. And just like any other valuable possession, it needs the most secure protection possible. If you already have a trademark or are creating one, you can secure legal proof of ownership by registering your application with the National IP Office. It's something that you can do yourself or with help of a specialist. But if it's in another country, a national of that country may have to register it for you. Whatever you decide, your mark will have to go through various stages before it is officially registered. As mentioned earlier, a trademark may include words, letters, logos, and the shape of goods or their packaging. An accurate representation of this mark and an application form will have to be filed at the National Office. Your application is then examined to establish whether the mark you have submitted fulfills the requirements necessary for registration. For instance, you won't be able to register a word or a device that is in any way descriptive of the goods or services it relates. What is more, objections may be raised if the mark is laudatory, a common surname, or a geographical name. Such requirements are fair to everyone because they allow competing companies to use words required in the normal course of their trade. In some countries, the next stage is to search through the trademarks register to see whether or not your mark conflicts with other registered trademarks or pending applications. If the application is not searched or the result of the search doesn't appear to infringe on any registered mark and it fulfills the requirements for your registration, your application should be accepted. The mark is then registered, and this registration gives you an exclusive right to use the mark for a number of years, depending on the country to which it applies. Trademarks are renewable indefinitely in most countries. If you intend to use your trademark in other countries, you will need to apply for registration in each country. If you're in any doubt on any of these matters, contact a trademark attorney or your National IP Office. History shows that the tradition of naming products after the place where they are harvested or manufactured is very old. Some products have become internationally recognized and is a part of the image of a region or a country. There are many examples of geographical and traditional names associated throughout the world with products of a certain reputation and quality. Examples here are champagne wine from France, Manchego cheese from Spain, Habanos tobacco from Cuba, Antigua coffee from Guatemala, Longjin tea from China, Basmati rice or Darjeeling tea from India, and Parma ham from Italy. Further examples in ASEAN are Nguk Mam Phu Quoc fish sauce and Muk Chao tea from Vietnam, Thai jasmine rice from Surin in Thailand, mangoes from Cebu in the Philippines, Kintamani coffee from Indonesia, Kampot pepper from Cambodia, to mention but a few. Since these products benefit from a certain reputation and therefore bear a higher value for consumers, infringers may be tempted to use these geographical names wrongly for products coming in from other regions, thereby misleading consumers. To protect such products legally, a dedicated intellectual property right, known as a geographical indication, has been created. Geographical indications, or GIs, are signs used on goods having a very specific geographical origin and possessing qualities or a reputation that are essentially attributable to that place of origin. Geographical indications are different from other IP rights in that they do not have to be invented or to be new to be protected. They merely have to be officially recognized by the relevant authorities to gain legal protection, as they may have already existed for decades or centuries and often be well known to the public. A geographical indication is not a simple indication of source, such as made in Cambodia or Swiss made. Such a reference merely specifies that a product originates in the geographical region, but without bearing a quality function. Geographical indications are also different from trademarks. Whereas trademarks put the emphasis on the owner of the trademark, a geographical indication highlights the geographical origin of the item or product and its characteristics, which are derived therefrom. Geographical indications are collectively used without individual ownership. To protect a geographical indication, the applicant needs to write down the product specifications, including the name of the GI, the region covered, the influence of the local environment and know-how, which make the product quality unique. For example, what makes the fish sauce from Phu Quoc in Vietnam and the jasmine rice from Surin in Thailand particular, and allow them to acquire the reputation. Geographical indications, once protected by law in the country of origin, can also be protected internationally for an indefinite period. For more precise information about geographical indication protection in your own and other countries, contact your national IP office or an attorney. Copyright gives rights to the creators of original works, such as technical descriptions, catalogs, and engineering drawings. And as you would expect, copyright normally protects original literary, dramatic, and musical works, published editions of works, sound recordings, film, videos, and broadcasts, including cable and satellite broadcasts. The period of copyright protection varies depending on the item, as well as on national legislation. Generally, copyright is an automatic right, so it does not have to be specifically registered to be effective. In some ASEAN countries, however, voluntary registration exists. For more precise information on copyright protection in your own and other countries, contact your national IP office or an attorney. All rights that have been mentioned are territorial. That is, they apply only in the country in which you have applied for those rights. So, if you already have or expect to have a market or markets in other countries or manufacture abroad, you should think seriously about applying in those countries also. Laws vary from country to country, but the various aspects of intellectual property are broadly similar. There is an ongoing worldwide movement towards harmonization of national laws designed to ease trade between countries and encourage the inward transfer of essential and innovative technology. Without such rights, an individual is likely to have the results of his efforts and dedication stolen by others. Countries in need of that technology also suffer if such rights are not available and enforceable, because investment will not be made without that protection. Also remember that licensing agreements involving such rights often embrace other vital intellectual property, such as know-how. To obtain equivalent foreign rights, you can apply directly for national patents and other intellectual property protection. However, there are also several international and regional treaties which can make applications for protection easier and which may be available to you. Always bear in mind that legal protection may be derived from the registration of intellectual property rights. They are subject to national law, and an infringer can be sued before the national court in the country where the infringement took place for, amongst other things, compensation, damages, or confiscation and destruction of the goods. In some countries, there is a judicial specialization for intellectual property, with dedicated courts judging in civil and criminal intellectual property cases. When you apply for a patent or want to register a trademark or GI, should you seek professional help or do it yourself? Provided that an applicant has his residence or place of business in a country concerned, he doesn't need to be represented. Such an applicant may, however, be represented by a patent or trademark attorney. A patent or trademark attorney is qualified to deal with intellectual property matters and is usually registered with a recognized professional body. It is certainly advisable to obtain professional help as soon as possible. Wrong wording used in the application may render the whole or part of the application useless, so it makes more sense to have it drawn up correctly to give it a better chance of success. If you want to protect your innovation, your products, or your company's reputation, and make the most of its business potential, It is important that you take advantage of the valuable protection and scope for effective enforcement that is available. If you think your innovation, creation, or name is worthwhile and something that you can profit from, it is almost certain that your competitors will think so too. And at the end of the day, you should be the one to receive the financial rewards for what you have achieved. So don't forget to protect your intellectual property rights. They may be crucial to your success.